In the previous section, we examined the key distinctions between an owner's title insurance policy and a lender's title insurance policy, learning how each serves to protect different interests within a real estate transaction. Building on that foundation, this final section focuses on a critical document that precedes the issuance of either policy: the preliminary title report, often referred to as a commitment for title insurance. This report is the backbone of the title insurance process. It outlines the ownership, encumbrances, and conditions of title that must be satisfied before closing. Understanding its structure and purpose enables real estate professionals to identify potential issues early and ensure that the transfer of ownership proceeds smoothly and legally. The purpose of the preliminary title report. A preliminary title report, or title commitment, is a document issued by a title insurance company before closing that discloses the current status of the property's title. It is not yet a policy of insurance, but a promise to issue one once specific conditions have been met. Its purpose is to inform all parties, buyer, seller, lender, and escrow, of any existing claims, liens, easements, or other matters that may affect ownership. It also specifies what the title insurance company will and will not cover in the final policy. In Arizona, the issuance of a title commitment is a statutory requirement under ARS Parv 20-1567, which mandates that title insurers conduct a thorough search and examination of public records before issuing any title insurance. This ensures that coverage is based on verified information, not assumptions. The Arizona Department of Insurance and Financial Institutions, DIFI, regulates this process, ensuring that all title companies meet professional and ethical standards in preparing title commitments. Structure and content of the preliminary title report. The preliminary title report is organized into distinct sections, each serving a specific purpose. Understanding how to read and interpret these sections is essential for both licensees and clients. Schedule A, the facts about the transaction schedule. A identifies the key details of the transaction and the property itself. It lists the effective date of the title search, showing when the records were last examined, the name of the proposed insured, the buyer and/or lender, the current record owner of the property, the legal description of the property, the policy amount and type, owners or lenders. For example, in a typical Phoenix residential sale, Schedule A might show that John and Mary Adams are the current owners and that the proposed insured is Michael Brown, a single man, with a purchase price of $525,000. The legal description provides a precise definition of the property boundaries, ensuring there is no confusion between adjacent parcels. Schedule B, Part 1, Requirements. Schedule B, Part 1 outlines the requirements that must be met before the title company can issue a final policy. These typically include payment of outstanding liens, judgments, or taxes, execution and delivery of a properly notarized deed, recording of the deed, and any necessary loan documents, proof of payment for assessments or HOA dues, any other condition needed to clear title. For instance, if the seller has an outstanding mortgage balance, that loan must be paid in full and the lien released before closing. Similarly, if the property lies within a homeowners association, the escrow officer must confirm that all dues are current. These requirements must be satisfied in coordination with escrow before closing proceeds. Schedule B, Part 2, Exceptions. Schedule B, Part 2 lists the exceptions to coverage, matters that will not be insured against by the title company. Exceptions may include easements for utilities or access covenants, conditions, and restrictions, CC&Rs, recorded by the developer encroachments, boundary disputes, or unrecorded rights-of-way mineral rights reservations or water rights agreements, lines or assessments not yet due. These exceptions are crucial because they define the limits of title insurance coverage. For example, if the property has a recorded utility easement allowing underground lines along the back boundary, the title insurer will exclude that easement from coverage. This means the buyer cannot later file a claim against the title company for issues related to the easement's existence or use. How the report protects all parties. The preliminary title report serves as a safeguard for everyone involved in the transaction. The buyer gains awareness of any restrictions or encumbrances that might affect ownership rights. The seller learns what debts or liens must be resolved before closing. The lender uses the report to verify that its mortgage will have a valid first lien position. The escrow officer relies on the report to coordinate payments, recordings, and releases. A practical example illustrates its importance. Suppose a buyer is purchasing a home in Mesa, and the title report reveals an old mechanic's lien filed by a roofing contractor from years earlier. Although the seller was unaware of it, the lien remains on record. The escrow officer, using the report, contacts the title company to obtain a lien release before closing. If this issue were not identified early through the preliminary title report, it could have clouded title and delayed the transaction. Legal and practical importance. The preliminary title report is not itself insurance. It does not provide coverage or guarantee title. Instead, it is a disclosure and a commitment to ensure once the listed requirements are fulfilled. Its contents can have binding legal implications because they define the title, insurer's scope of coverage, and exceptions. Arizona courts, including in First American Title Insurance Co. versus Action Acquisitions, LLC, 2008, have recognized the title commitment as a critical step in forming the contract of indemnity that becomes the title insurance policy. This document also reinforces the fiduciary duties of the escrow and title officers involved. As established in Burcons versus Ticor Title Insurance Commerce of California, 1991, these professionals must act in good faith, disclose known defects, and ensure that all parties are fully informed of material facts affecting the property. Any omission or misrepresentation in the preliminary title report can expose the title company to liability for negligence or breach of fiduciary duty. Discussion: why is the preliminary title report important in a real estate transaction? Answer: because it discloses the current condition of the property's title, identifies requirements that must be cleared before closing, and outlines the exceptions that will not be covered by the title insurance policy. What types of information are typically found in Schedule A of the preliminary title report? Answer: the names of the current owner and proposed insured, the legal description of the property, the policy type, and the effective date of the title search. Why should real estate agents carefully review the exceptions listed in Schedule B? Answer: because exceptions define the limitations of title coverage and may include restrictions or easements that could affect the buyer's use or enjoyment of the property. Review summary. The preliminary title report, or commitment for title insurance, is an essential document that bridges the gap between the title search and the issuance of a final policy. It discloses ownership, encumbrances, and conditions that must be satisfied to ensure clear and marketable title. The report typically includes 3 major sections: Schedule A, listing the property and parties; Schedule B, Part 1, detailing requirements to clear title; and Schedule B, Part 2, identifying exceptions to coverage. By reviewing the report, buyers, sellers, lenders, and escrow officers can address potential issues before closing, ensuring compliance with Arizona law and preventing costly post-closing disputes. Under First American Title vs. Action Acquisitions and Burcons Arches Ticor Title, Arizona courts have emphasized the importance of accuracy, disclosure, and diligence in title reporting as a means of protecting consumer interests and preserving trust in the real estate system.